Hey, it's Darius. Much effort and energy go into each I-75 video, but it's all worth it when you pass the CPA exam and notice the I-75 difference. So congratulations to I-75ers who let me know that they passed the CPA exam this week. If you didn't pass, don't get mad. Get on I-75 with me, Darius Clark, because the right teacher makes all the difference. I'll save a spot on this list for you next month.
All right, so this is a question on agency. Whenever they tell you someone's the assistant manager of purchasing, that's an agent. So Jay is the agent, Henley Corp is the principal. Jay has authority to enter into purchase contracts on behalf of Henley, provided that the price of the contract does not exceed $500,000. What does that mean? That means Jay's actual authority is $500,000 and no more than that. But does that mean that Jay will only be able to enter into contracts with a limit of $500,000? No. Jay's going to wind up entering into contracts that are over that amount, and they're going to ask you, is the principal liable? It just means that Jay shouldn't enter into contracts above $500,000 without the principal's permission, but of course Jay is going to exceed his actual authority. Let's watch it unfold. Renfro, who is the president of Henley, is required to approve any contract made by Jay or any other agent that exceeds $500,000. So that's the limit on Jay's authority. Jay entered into a $3 million purchase contract with Law-Darius Corp. Who's Law-Darius Corp? A third party, without Renfro's approval. Law-Darius Corp was unaware that Jay exceeded his authority. And they tell us that Law-Darius has sold goods to Jay before on Henley's behalf. What's the most likely result of this transaction? So here's the third party, Law-Darius, and they're looking to get paid $3 million for this contract. And maybe they're not looking for the $3 million from Jay, the agent, but they're certainly going to look to the principal for this $3 million. And what's the principal going to say? Well, our agent exceeded his authority. Yeah, but the third party didn't know about that limitation. So in the third party's mind, in Law-Darius's mind, Jay could have bought any goods. So the answer is Henley, the principal, will be liable for the entire contract despite the limitations on Jay's actual authority. Because this concept is called apparent authority, and in the third party's mind, they thought that the agent could order any goods. Why were they able to think that? Because it says the third party has sold goods to Jay before on Henley's behalf. So secret limitations placed on the agent's normal authority, that's what creates this type of apparent authority, and in this case it was certainly reasonable for Law-Darius to believe that Jay had the authority to enter into a $3 million contract since Jay has a position in the company as vice president of purchasing or assistant manager of purchasing. The fact that Renfro secretly limited Jay's authority has no effect. Let's look at these wrong choices. Henley will be liable to Law-Darius for $500,000, the amount of Jay's actual authority. No. The principal will be liable for the full $3 million contract because of apparent authority. C. Henley will not be liable to Law-Darius because Jay exceeded his actual authority. No. D. Law-Darius Corp. may not rely on Jay's apparent authority because Law-Darius had dealt with Jay in the past. No, that's why they can rely on the apparent authority, because they have dealt with the agent in the past.
Let's try this now. ABC Inc. hired Susan as a purchasing agent for office supplies. Susan was authorized to make purchases up to $10,000 without prior approval. After Susan was fired, ABC notified all suppliers with whom Susan had previously dealt. However, the next day, Susan entered into a $15,000 contract for office furniture with a new supplier that had never worked with ABC before, but knew of Susan and her relationship with ABC through various business contacts. Is ABC liable for the contract? A says yes because Susan had apparent authority to enter into the contract. B says yes because Susan had express or at least implied authority to act on behalf of ABC. C says no because Susan exceeded her authority by making a purchase over $10,000. And D says no because the supplier had no prior dealings with ABC and had no reason to believe Susan had authority. And the answer is A. Yes, the principal's liable because the agent had apparent authority to enter into the contract. Even though Susan was fired and that terminated her actual authority, the new supplier was aware of Susan's prior relationship with ABC through various business contacts, they tell us. And although ABC gave actual notice of dismissal to current customers, ABC did not give what? Constructive notice, which is necessary to terminate Susan's apparent authority. All ABC would have had to do to avoid apparent authority is to publish Susan's termination on the internet or in a trade journal, because that's what we mean by giving constructive notice, making a public announcement, publishing the information so that any interested party who wants to look it up has a place to do so. So the question asked, is ABC liable for this new contract entered into by Susan even after she's been terminated? And the answer is yes, because although the principal gave actual notice, they failed to give constructive notice. And on the exam, that's often the answer to a multiple choice question on termination of agency. Look to make sure that the principal not only gave actual notice to current customers, but they also gave constructive notice to the rest of the world. Hey, it's Darius. Much effort and energy go into each I-75 video, but it's all worth it when you pass the CPA exam and notice the I-75 difference. So congratulations to I-75ers who let me know that they passed the CPA exam this week. If you didn't pass, don't get mad. Get on I-75 with me, Darius Clark, because the right teacher makes all the difference. I'll save a spot on this list for you next month.